Ladies and gentlemen, welcome back to the Indie Zone podcast. On the 24th of April, 2025, Judge Hippler entered an order on the defendant's motion in limine regarding vague and undisclosed expert testimony. This order says, page 1, defendant moves to limit or exclude several different experts disclosed by the state on the grounds that their disclosures are deficient in some regard. Now, you'll recall that on October 9th, 2024, Judge Hippler rendered in his pretrial and trial order a schedule of what both sides were to disclose to each other regarding expert witnesses to comply with the rules of evidence, what they would be expected to testify at trial. This order goes on to say the state responds that it has complied with all discovery obligations and its disclosures are sufficient. So they're raising the fact that they believe they did nothing wrong here and the motion should be denied. The state also adds that several of defendants' challenges are fodder for cross-examination, not exclusion. What does this mean? Well, basically what the state's saying here is that certain of the defense's complaints, their challenges, they're basically appropriate for the defense to raise on cross-examination, not to exclude or to limit the experts. And Judge Hippler basically agrees. It says here in the next paragraph, the court finds no basis to exclude or limit the disclosed expert testimony at this time. However, the court's leaving the door open for trial purposes that the defense, if need be, can take action if they feel that an expert witness is testifying outside of their range or what was disclosed, because it says here, but if defendant believes an expert is testifying at trial outside the scope of his or her disclosure, he, meaning Mr. Kohberger, may object at that time, and the court will consider it at that time. That means trial. These experts that are listed in this order will be entitled to testify at trial, with the caveat being that Mr. Kohberger can raise any objections at trial consistent with what the court's writing here. Now, there's some information in this order regarding what the expected testimony would be that either, in my opinion, confirms what has been released recently to the public regarding the circumstances surrounding these extremely tragic crimes, or includes new information. And one example is on page 10. This relates to the testimony of Dr. Gary Dawson, state witness, ladies and gentlemen. It says here, Dr. Dawson was disclosed in rebuttal by the state to testify to, quote, the degree of impairment of the victims, particularly Madison, at the time of the crimes, end of quote. Dr. Dawson's expert report, ladies and gentlemen, attached to his disclosure opines, that means he's giving his opinion as an expert, that Madison would have been, quote, markedly intoxicated from the effects of alcohol around the time of her unaliving. She would not have had the ability to mount a meaningful response to a sudden threat to her person, end of quote, inciting to Dr. Dawson's report. The court then adds, he, meaning Dr. Dawson, further states that while he has limited his review to Madison, that, quote, the same general principles, end quote, apply to the other victims. So we just see some very tragic anticipated testimony here that not only were the victims at a severe disadvantage because they were taken at surprise in the middle of the night, 4 o'clock in the morning, rather than the middle of the day from a half mile away seeing somebody running toward them, where they might have been able to mount a meaningful defense. The fact that there's intoxication level added to this makes their ability to have protected themselves basically even that more diminished. This is Kathy. Thank you for joining us here today.